habit of requesting permissions and following the right protocols so that there's a bit more of a cooperative environment for when things really do get infringed on. We've already set the precedent for follow-up, and maybe that practical enforcement part will be that much more possible. Because I think what I'm hearing from like friends, I have friends who are authors in Zim, I have friends who are designers and tech people and whatever, and they are freaked all the time about getting, and stuff is getting lifted constantly, and they have no recourse. They have no recourse. So that's the thing. It's like there may be these international laws if somebody's stealing your stuff in Sudan, but practically speaking, what are you going to do about it? Nothing. There's nothing you can do about it. So maybe one idea is just to try this collective effort to raise the awareness and the sort of, yeah, the best practice amongst publishers.
The one thing Moses did say is, what is your fear? The lady who was worried about not having copyright written and signed and enshrined. What worries you?
That's like you're saying that copyright is automatically
No, but what is your fear? Have you written something and you think people will steal it?
No, I just want to defend my work.
Thank you. There's a comment in the back, and then after that.
I think something that may or may not set people's minds at ease, worrying about enforcement protection, is that the judiciary had started a process of an intellectual property tribunal, which would be a cheaper, faster way than having to go to the courts, having to go to some intellectual property office. And at our firm, we're trying to find out what the progress is on that. But I think that would go a long way in giving people confidence in producing works here and knowing that they won't be infringed. Unfortunately, like quite a few things here in Zim, it will take a bit of time. But I think once that mechanism is in place, then there will be a faster, smoother way to assist people to protect their IP.
Abel and Taps, do you have something administrative? Okay. Abel, thank you.
I was going to speak about the newspaper and almost I would think maybe what I was saying, maybe we need a dialogue between newspapers and publishers so that people can really come up with what we would say best practices when dealing with the other. But normally newspapers, they don't really serialize the books. Normally they do book reviews.
Yes, so, I was just questioning, sorry, I was just questioning the interpretation that Moses had given to seek for clarification, because I thought maybe I hadn't understood it correctly, and that was clarified.
And so, of course, the challenge is sometimes you go on Google to take a picture. So when it is AFP, BBC, normally in the Herald, we do acknowledge where the picture is coming from. But then when we search engine Google, yeah, then that becomes a challenge. We just put a picture there. We feel, yeah. With Google, I think there's that belief that it's really public domain. But when it is AFP, BBC, I think with original newspapers, I think with BBC, AFP photos, I think they're going to acknowledge. And then the issue of someone was talking about their pictures being reproduced then here and there again. I think if you go, if you are following the newspapers, they will actually acknowledge you. What happens is I write an article in the year 2000, and then I put the picture. I mean, I actually know who this person was, and I can acknowledge. But then that picture remains in our library system. So 5 years later, when another person writes a story, as a sub-editor, to look for an appropriate picture, I was just going to pick up that picture, but the way it is now, it no longer is with that acknowledgement of going to the picture. So then I'm just going to put the picture there, then put a general caption and say some of the fashion trends in Zimbabwe. So I may not exactly, I may be infringing upon your rights in ignorance, because I now don't know who, because the next time who did that, who put that picture onto a page, did it 5 years ago, and then some of the information has been lost along the years. So sometimes I think people should really feel free to come in approach and say, But this is my picture. I think it will be
That dialogue is a fine thing if the people will talk. We've had 2 or 3 cases of a particular newspaper, not your own, which hates us as a publisher, reproducing photographs from our website. I write to the editor, who is supposed to be a professor of media studies at the company.
Okay.
I don't even get a reply. You can't talk to those people about copyright or anything, and if you do challenge them, in the next edition of the paper, headlines are, we were press a racist or something.
Taps, I think you had a comment, and then in the next.
I have a question for those practicing law in the room. If, let's say, I've created a work, right, and then I find that someone is infringing on my copyright, and I approach that person, I tell them to stop, and they don't do it. If I then approach a legal firm, right, and I say I found someone, right, who's infringing on my work, and I have proof, this is proof that there's the date and everything is done, how willing is a legal firm to actually take on that case and then to prosecute that person? Even, for instance, if I don't necessarily have the money to pay fully for the legal services, understanding perhaps that, I don't know if this is the case in the legal system, but if, let's say, I take someone to court and they lose, then they have to pay my legal fees. Is that right? So if I come to you like it's like a slam dunk case. He's infringing on my copyright. Here's the proof. Would you take this on, understanding that you collect your legal fees once the case is kind of gone through 2 years or like, do you need deposits and that kind of thing?
Well, that's a very interesting question, because only just recently has the Law Society actually published something and said contingency agreements are going to become legal or acceptable in Zimbabwe. But right now it's at a stage where the SI, which really enforces it to become law, is still being drafted. So it is going to be very possible in the near future, because it's something that the Law Society has actually, the Law Society did publish it, right, in the newsletter, to say that contingency agreements are going to become possible. So pretty much what contingency arrangements or fees are is, if someone comes in, they have a solid case, you say, listen, I will take on your case, and when you do win the case, or if we do win, I will then get my fees or remit my fees after the completion of the case. So is that, did I get your question right?
So that's in the process of actually becoming law.
When is that statutory?
It's not yet out.
Oh, it's not.
They're still, they're still working on it.
But like this year, maybe?
Yeah, hopefully this year, because I mean it's something that the Law Society has, informed lawyers that they're working on and soon going to become law.
And at the moment, if, let's say, if that hasn't come out yet, at the moment what would be normally the process? Do you kind of engage and then you kind of sign some kind of agreement where you put a certain amount down and you pay down? Like what's the process right now? The question was about basically approaching a law firm to prosecute someone for copyright infringement, right?
Oh no, I got the original one you just asked.
The one I just asked, like, what's the process right now? Like someone actually comes right now with the case of copyright infringement, what would you actually do and say, okay, I mean, not the actual fees, but like, what's the process? What can we kind of expect?
I think what you want to answer that? I think the issue that arises in terms of litigating and actually taking matters to court will always be disbursements. I mean, if you have a slam dunk case, a reasonable law firm will say to you, look, we need disbursements for the court process. If we're filing any court application or summons, there are obviously disbursements that need to be made. I know that there are some law firms who will ask for the exact. You have a letter of engagement, and the letter of engagement says to you, "This is the fee. However, based on prospects of success, the only money we will need from you is for disbursements." And then obviously the scale of fees that's applicable in your court document will come into play. I think it really does depend on on how the law firm that you approach works. There are some who will say, look, give me my $500 now, this is your deposit, we'll bill you at the conclusion of the matter. And then there will be other law firms who will maybe be a bit different and say, look, disbursements will come to this much, may you give us this cash. But I think the SI really will help because it essentially boils down to no win, no fee. And it's widely used in America, and it's successful. I mean, it does dangle that carrot to say, look, let me work as hard as possible.
Let's get a couple more questions here. So
the last portion of that question.
Just because you understand.
Has there ever been a case where a third party can step into the process and say, I will pay this amount right now to engage you as a law firm, with the understanding that if you win as a third party, I will then recoup the amount that I've spent you, so that the person who you're actually representing doesn't pay the full amount for engaging? Or could that possibly do it? It's almost like copyright insurance, isn't it?
It's like third-party procedure. That would...
I think it's all about the agreement between the third party and the client you're representing, because I think as long as you know the third party has some form of contractual agreement with the person that we're representing, I think that would be a side arrangement between themselves.
Okay.
And
Another good question. So I think we've got a question here, a question back here, and then who's up? Yeah.
Okay, just to add on to what they're saying, I think locally in Zimbabwe there are some lawyers who do pro bono stuff in terms of intellectual property, and I think Moses is one of them. If your case is good, he does it for free, he can do it for you for free. So there are some people like that. But my issue goes back to digitization, mass digitization, and copyright. We're talking about fair use, but I think one of the issues that has brought this discussion about is the Google case. And what Google did was it's scanning books and making them available online without the author's permission. And they won the case on the basis that they're doing that for fair use. So that means they've got no rights. The author has not given them any rights in terms of the economic rights, the moral rights, any rights. So I'm saying, what do people feel about that locally? Do they think it's fair for mass digitization organizations or companies like Google to take their work, put it online, and they are saying they're not really getting any economic benefits directly, but I think indirectly they are. So what are people thinking here in Zimbabwe? Because probably some of our works are actually going onto those platforms.
Any that?
I wanted to ask that.
Feel free to respond to that as well as you.
Yeah. It was mentioned earlier about Amazon and something about self-publishing. How is the process in Zimbabwe? Can you actually write a book and self-publish?
The current process in Zimbabwe for self-publishing is like, there are not really self-publishers, but you go to printers and you print on demand. They will just print whatever you want. If you want 10 copies, they print for you. Yeah.
Okay, sure. Go ahead.
Yes,
sure.
I wanted to ask if you could, I think you can give me a better answer because it's from your experience. Isn't it you can get an ISBN number before your book is published? Because I've just done that.
Well,
She wants to close.
you can. And when you go to the National Archives for an ISBN, you just have to fill in forms, title, author, date of publication, form of publication, signature, and they will give you a number. And you are obliged, under the Printed Books Act or something, to lodge a copy with them when it's published. Now, the archives had a little bit of trouble a couple of years ago when we started getting ISBNs for soft copy editions of books. And they said, when are we going to get our copy? And I said, well, frankly, you're not. And the physical book we can give you. It doesn't oblige you to publish. If you don't publish the book, print it, the National Archives may write to you in 6 months' time and say, what happened to that book? And you say, oh,
My question then is, because I'm trying to publish it on Amazon, but they don't actually, they don't really need an ISBN number, they say, but they say you can purchase one online. What do you say about that?
well, the answer is I don't know. I think anybody who publishes a book in Zimbabwe is obliged to go to the National Archives to get an ISBN. I don't know whether the law under which that happens says anything about somebody who's publishing with Amazon in the cloud. Is that then a Zimbabwean book subject to the rules of the National Archives? I don't know.
Do you know the answer?
Okay.
But he's just mentioned what we're going through. We published our book with an American publisher who then put it on Amazon. But we were using some information that is, because we are a Microsoft partner, so we were allowed to use some material from the official Microsoft curriculum. But now the problem is, it's there on Amazon, we've got 1 or 2 copies left. We're struggling to let them allow us to bring in books so that we can distribute it locally. So what we're now trying to do is try and find a way of it being published locally. So we have no idea of where, how, and how to do it, but that's what we want now, so that if people here have access to it. Because the scenarios that are in the book, project management, are situations that happened here, so we want people to enjoy the book here.
Yeah, so like what's the local copy?
Like, we need more.
I just wanted to try and comment on to have to say now that the issue is in your contract with the American publisher.
What not even responding to emails.
I mean, like,
Was not even responding to emails.
no, I mean, like your contract, are they the sole publisher, or what sort of agreement do you have with them? Because that is also going to matter. If you are going to use a publisher in the US and they're the only ones that you said you are the only publisher, then you cannot come to Zimbabwe and use another publisher. According to copyright law, it will be an infringement. So we have to actually look at the kind of contract that you sign.
I think there was a question here.
Just to add to his question and to what the lady over here and the gentleman over here said, you call them contingency agreements, right? Like when you agree with the lawyer that they'll get paid after they win the case, like if it's a straightforward case. And you said right now there's a law pending to allow that. And you also said that if you agree, currently if you agree with the lawyer that they'll get paid and they see it's a straightforward case and they can agree to it and go on with the case, does that mean that when the law has been passed, it's not going to be at the lawyer's sole discretion to reject or accept a case?
No, it will. It's just that previously contingency arrangements or contingency fees were not legal in Zimbabwe. I suppose it was also just purely for lack of being...
Would it be illegal right now if I get like a letter of agreement, if I agree with the lawyer and we write down, and would that be...
Well, right now, yes, it's not really, it's not legal, because before it was prohibited in terms of just the code of conduct. The Law Society didn't permit lawyers to enter into contingency arrangements or contingency agreements. So before, just as a matter of code of conduct, it wasn't permissible. But the Law Society has said that, it's something that is going to be, permissible in the near future, and that the SI is actually is on drafting stages. It's being drafted. Yeah.
Okay, my question is, there was a website called bookauth.org. It was uploading books by different people. And then it was shut down because it was giving out books for free, but it didn't have permission from the authors. And we were talking about Google Books, that they uploaded books without permission from the owners of the books. So my question is, that website was shut down because publishers were complaining that they didn't have the right to publish that work. So what's the difference now? That website was shut down, but then Google is doing the same thing.
It's a lot of money and bigger
Let me go the answer. Man in white.
One of what, I mean, like, Karen in her presentation, she indicated that with Google you are able to actually do a search. It will be able to bring to you, to say so and so has this thing. And just give you just some snippets about the business, not the whole. So that is where the American court said it was fair use because they are not giving you the whole book. And even when the book is there, you are able to see that so and so in Zimbabwe wrote this book, and maybe you are able to get an idea of what the book is saying. You cannot download it. So for you to download it now, you have to buy it. So that is the distinction. So the website that you are talking about, the way I understand is that it was availing the works just for free.
Okay. So are you saying that even if a book has not been digitized by the owner, Google can still have, can still show it to people that there's this book that is,
yeah.
But then if they want to buy and it's not online, what happens?
No, then I think maybe it's a question of, because the way Google got away with this is that it's more like they give you information about something that exists. Then for you to access that, then now you have to go an extra mile to say, okay, fine, maybe this book was written in Zimbabwe, it's not available in Amazon, it's not available in iBooks. So how do I get it? Then maybe we can see who the publisher is, then we contact them and sort of get it.
And to add to my question,
Sure.
if you keep my mind, I'll come back.
Okay.
I'll come back to it.
Yes, I just wanted to comment on the issue of the Intellectual Property Tribunal. The act was passed sometime back, and I think it's there. But it's not been used to date because there have been no cases which required it to sit. I understand the tribunal will only need to be appointed 3 people capable of being appointed judges and the current sitting judge. And then they'll look at any case if it comes up. The act is there. I don't think it has been repealed. It was passed more than 5 years ago. Yeah, they need to be awareness. The law is there. It is up to us to use it. The other case about taking infringement cases to court, as the lawyers here are saying, going to court is expensive. Most authors are more concerned with the issue of preventing others from infringing, encouraging more awareness, working together, working with publishers, and stopping it from happening. So you have to work with the authors, organizations, and your publishers to ensure and guard against your works being published. I think you will get better mileage there than trying to sue. Because even if when you sue, the damages are very, very difficult to quantify. And you will find that the cost of suing are way, way beyond the benefits that you are likely to get. So the objective is to stop infringers from infringing. The people who are now being taken to court are pirates. These are people who photocopy all books, reproduce all books, and try to sell them in schools to your customers. Even that has been creating problems with the law enforcement agents. But that one has to be stopped, and people have been taken to court, but some of the cases have not yet seen the light of day for one reason or another.
Sir, and then...
I think I just want to answer a question that was asked earlier about what publishers, or how publishers feel about digital distribution, especially digital distributors putting their books online. And I think what's also happening is there's an evolution happening with ebooks, and the biggest disadvantage of ebooks is piracy, but that unfortunately is much more complicated to take away. But one thing that has been realized is that usually when an author makes their work available, despite piracy, usually they get more income from the book. Because piracy in a way also translates to exposure and stuff like that. So some publishers have actually realized that even when they distribute their books, and these books are being pirated, they actually get more revenue than they do without distributing their books online. So what usually happens is, for example, a publisher can decide to only distribute physical copies. They print 100,000 copies and only 80,000 copies are sold. But if that same publisher, for example, decides to distribute that book online, they could have 500,000 people pirating that book. But they also had to record maybe 700,000 people buying that book. So there's also that dynamic, because there was digital rights management where publishers were coming in, they're controlling how books were accessed. But I think Lulu.com recently removed digital rights management because they realized that in the long term, it's actually more beneficial simply because of economies of scale and exposure. Because for a person in Zimbabwe, if their book is being distributed solely by them, and everyone who's sort of like sharing information about that book has bought it before, chances are not too many people will know about it. So it's a complicated thing to understand, and I wouldn't go as far as saying it's a good thing, but it's also a fact that's sort of like emerging behind the scenes that piracy might not be all that bad. So sometimes if a publisher has a number of books, it's a difficult thing to understand, but in terms of economics, it's proving that there's this very complicated concept that's also emerging, and it's very difficult for people to understand. But in terms of pure economics, you can actually make more sometimes when your book is pirated. I'm not saying it's a good thing, but that's the thing.
I think we have time for maybe one last comment. Did you have a contribution? No, I thought I saw your hand. No, okay. Okay, last burning contribution.
I remember my question. I talked about book.org. They were shut down. I want to know who's responsible for shutting down websites. Let's say some other website like that comes up, and then you want to report. Is there like some organization that works online to do that?
Yeah, the World Intellectual Property Organization, is that true? RIPO is part of that.
The issue of privacy in the cyberspace is a very hot issue that is being debated in terms of jurisdiction. Where do you go to sue in the first place? Because sometimes you don't even know where the person who did that stuff online is. So it's quite a debated issue. But in some countries you find that they've come to a point of saying that there are these, what do they call them,
Internet service provider.
Yes, those are, because if we have to have a website here in Zimbabwe, there's somewhere where you register and all the like. So in some countries they have been able to come up with laws where the ISPNs are obligated to actually shut down a website if it is violating some laws and everything. So in some instances where you know where they are and who they are, then you can be able to come forward and maybe through the court system get them shut down. But it's a very complicated thing to deal with. It's giving IP experts and even IP rights holders in the world a headache at the moment.
Something really quick?
Yeah, really quick, sorry. I just wanted to know if maybe Hypercube or Evan or whoever, I like the idea that seems to be emerging around, and I said this too, but anyway, but maybe like this could become a forum or that we build off of this to try to do something more about an enabling environment kind of approach. And that if maybe a listserv could be started by people who are in this room who are interested, we could be sharing some information amongst ourselves and maybe building on that as well. But that this could be a good sort of starting place.
Do people like that idea, or do people want to contribute? We could try to share some email addresses and stuff if that's helpful.
Yeah.
Okay. Well, maybe we'll think about how to do that.
Okay.
Yeah, we can even send emails out, and then if you want to be part of a listserv or something, then you could respond and opt in. We wouldn't just send you junk emails.
I just want to say with this, I've got a friend of mine, she had a contract in the UK to have the books published. The book poetry, right? So the book was actually published, and I've forgotten the name, Never's Press or something, that's the name of the publisher. They published the book for some time and she got royalties for some time. And then after some time they told her that your book is not selling, you put it off the shelf. And then one day she was booked doing, she actually saw her book. She's worried and she doesn't know what to do. She saw her book selling on Amazon for £60, but she's not getting anything from Never's Press, and it indicated that it's being printed by Never's Press, but she's getting nothing from them, and she doesn't know what to do. Do you know your lawyers? Please advise. Please advise.
I think that maybe we can follow up afterwards on this specific issue. That does sound like something that's very important to follow up on now. I just want to thank everybody for your really candid